Columbia University, one of the top academic institutions in the world, has a long, well-established tradition of international studies. Under the leadership of its current president, Lee Bollinger, it is seeking to become a truly global university for the 21st century. To that end, it has taken remarkable steps towards further globalizing its vision, its curriculum, and its teaching. It is also establishing a number of new initiatives, including Columbia Global Freedom of Expression, which was established in 2014. Columbia Global Freedom of Expression seeks to advance understanding of the international and national norms, institutions, and jurisprudence that best protect freedom of expression and information. We commission and undertake research. We organize conferences, and we participate in global discussions and debate on freedom of expression and information in the 21st century. It is supported by an international network of some 100 legal experts and by some 15 legal researchers coming from around the world, all together speaking more than 15 languages. Annually, Columbia Global Freedom of Expression recognizes a legal ruling and legal services that have upheld international standards on freedom of expression. In 2016, the Legal Service Award went to 3 Turkish lawyers who defended internet freedom at the European Court for Human Rights. The Best Legal Ruling Award went to the Norwegian Supreme Court, which upheld the protection of journalistic sources in the context of counterterrorism.
The Case Law Database is our flagship project. This unique global resource, accessible to the public for free, surveys jurisprudence from around the world. It analyzes decisions and focuses on the extent to which they refer to international standards and jurisprudence outside the national jurisdiction. It adopts a much-needed global perspective and standpoint.
The judicial sector plays a key role in protecting freedom of expression, but to do so, it must be able to respond to existing and new challenges to this fundamental human right. The court database has been designed by and for those on the front line of the judicial and legal system to protect freedom of expression. This includes judges, lawyers, policymakers, and students and scholars of freedom of expression. We are thus particularly grateful of the opportunity to partner with UNESCO, de Justicia, Universidad Externado de Colombia, and FLIP to establish the Global Freedom of Expression Court database in Spanish and to ensure that significant decisions from Latin America are included in Columbia Global Freedom of Expression database.
The Spanish language section of the database hosts nearly 200 case analyses from 15 countries in Latin America, as well as seminal cases from the United States, Africa, and Europe. The English language version of the database includes over 600 case analyses and case briefs from more than 89 countries. Around 20 analyses are added every month. They include recent judicial decisions and older ones that are seminal or precedent-setting. Our cases are truly diverse. For instance, we have included a decision dealing with protection of sources and counterterrorism from Norway, and a case on defamation convictions of a very famous caricaturist from Malaysia. Each case analysis lists the relevant facts, the applicable law, and the arguments presented by both parties. Most importantly, the briefs thoroughly summarize the legal reasoning that courts follow in making a ruling, thus allowing judges and other legal professionals to better understand how freedom of expression norms are adjudicated in national, regional, or international tribunals. This in turn makes them more capable of dealing with these issues in their jurisdictions. People rarely hear about the legal battles that go on in the courtrooms across the world to defend and argue over freedom of expression. Columbia's global database in English and now in Spanish provides knowledge about these cases and improves our understanding of global jurisprudential and legal developments. It's our hope that this will assist not only judges, lawyers, and civil society actors, but also law enforcement, scholars, and the general public in understanding the complexities of this right and upholding the international standards that have developed over time, including through an integrated global jurisprudence.